Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Hey, Jim Potts back on the air. Good morning, evening, or whatever time that you're tuning into me. Hey, before I get into the main topic today, which talks about the FMLA notices being sent via snail mail, I got an inquiry to ask my opinion about a fireman who was afraid of fire, and they wanted to know whether or not that's a disability. And here's what the circumstance was. Apparently, this firefighter that was out of Texas got nervous every time he went to a fire to start putting on his gear, to fight this fire. And the employer, his agency that he worked for, I guess turned around because he wasn't able to fight the fire, couldn't put on his gear. They turned around and sent him to their training facility to work at the training facility, which apparently meant, he was demoted. And he got upset about that, and he goes and he files in Superior Court, and Superior Court turns around and gives this guy $362,000, and saying that they shouldn't have demoted him. Well, now wait a second. Is this a disability? Because that's what he tried to argue. And it went all the way to the Texas Supreme Court. And guess what? They threw it out. They said, The court said the capacity to play, as an example, the reason why they threw it out is the court reasoned that, look, the capacity to play professional basketball is an ability. The rest of us do not suffer from a disability because we cannot play at that level. So in this particular case, is what they were saying is that not everything is considered a disability under the ADA. The court also noted a job skill required for a specific job is not a disability if most people lack that skill. Being reluctant to charge into a burning building is not a mental impairment. It is a normal human response. But firefighters are required to overcome that response because of the position that they're in. So the Texas Supreme Court threw it out. I'm really glad that they did. I remember we had a guy with the Sheriff's Department, when I was working with the Sheriff's Department, where he came out and because they require that you work in the jail system for 2 years. And this guy had an issue when he came out of the jails and started working patrol. You're on, we called it back then probationary period for 6 months. But every time this guy encountered a black citizen, this guy got really nervous. He was Caucasian, really nervous, sweating profusely. And you have to ask him, what's going on? He says, well, I grew up in a neighborhood where we learned that black people were very violent people. And every time I'm, around, these people as I'm encountering on the street, that's the kind of thing that's haunting me. And I get really nervous and, nervous about it. This guy eventually couldn't make it. Because how are you going to be a police officer and you get nervous regarding, encountering, black citizens and being too nervous and sweating and can't interact with them. And now, of course, there's a lot on the news about people, police officers and everything with this business about shooting black citizens. I'm not trying to get into that because I'm really an advocate of the police department and the work that they do. So at any rate, these things, whether or not that's a disability or not, who knows? But according to Texas, the Texas Supreme Court, I love that decision. All right, let's get into the main thing that I want to talk about today. This issue about FMLA. When people go out on FMLA, they don't always go out, with notice. They may end up going out because they're ill. Now they end up staying out a week, maybe 2 weeks. And now all of a sudden you're in a situation where they are recognized that it might be an FMLA situation. So the employer then sends out the FMLA paperwork to the employee. They call it snail mail. Now, typically courts have recognized the mailbox rule in which documents sent by regular postal mail are assumed to have reached the addressee. But now is what's going on, and FMLA is federal, so we're talking on a federal level, federal courts. A new federal court of appeals ruling is making employers question whether sending out FMLA notices via the regular mail process. And the case was a college employee sued after she was fired for not returning to work after her 12 weeks of FMLA. She said she never received the FMLA notice. The college said that they sent it via regular United States Postal Service. Now, the court sent the case to a jury trial because what they tried to do was get out of it by saying they had sent it and they must have filed, and the court said, no, we're going to send it to the jury. So the court sends the case to the jury, saying that certified mail gives a strong presumption of receipt by the person, while regular mail gives a weaker presumption. And surprisingly, the court sent a letter via regular mail is not considered delivered if the addressee says that they didn't get it. That happens all the time. Now, the mailbox rule is an old established rule, so that's why employers have used it. Now, this business about whether it's sent as certified, and this is what the court says, if you send it certified, there's a stronger presumption. Well, if you send it certified, you're going to get a signature. So it's more than just a strong presumption. The person receives it, they signed for it. Now you know they got it. Here's the problem. Think about it. And I'll lay this out there to you. How many times have you seen something that was certified coming to you and you didn't want to pick it up from the mail? Because what could that possibly be? If it's being sent certified, especially from your job, that might be information you don't want to know. So, because you're being fired maybe. So, in my opinion, employees typically will not go and pick up a certified letter. So then where are you at that point? Well, look, send them both. It's only 40 some odd cents or 50 cents, whatever it is now to send a regular letter. Send a regular letter as well as sending it certified. Send it both ways in case they don't pick it up. At least you have something to fall back on. Now look, the court's reasoning. It is certainly not expecting too much to require businesses that wish to avoid a material dispute about the receipt of a letter to use some form of mailing that includes verifiable receipt when mailing something as important as a legally mandated notice. Here's some advice. Employers would be wise to send benefit notice by certified mail or other method with a tracking service, especially in states covered by, from a federal standpoint, the federal protections. What about email? Well, let me just tell you something about email. Workers can also claim they didn't get the email. So that's not going to work. So this business about certified, let me tell you something. If you're going to send it regular mail, let's say that you owe this employee a check. If you send out that FMLA notice in the in an envelope, and you've got a check in the envelope, if they've cashed the check, which they're going to do, you can always fall back and say, you know what? In that envelope was the FMLA notice and also a check. They cashed the check. They had to have gotten the FMLA notice. So that's one thing that you could do if there's a check that's forthcoming. So keep that in mind. Yes, according to the court, send it out certified. That's always going to be the way to do it. But in fact, if the person doesn't go and pick it up, you're still back, in my opinion, to the same situation. All right? So, use your best judgment. That's the information. So do what you have to do. Look, I want to take a moment to look at something I want to put out there to you. 3 steps to a lawsuit proof hiring process. So a lawsuit proof hiring process. Listen, supervisors and HR professionals can only discriminate against applicants if they know the applicant belongs to a protected class group, age, sex, race, disability, etc. And we had one of those one time where somebody sent in to one of our clients out on, the person was in New Jersey and they were disabled, and they sent in because they saw an ad posted, and they sent in their application and resume, and they wanted to argue the reason why they didn't get hired was because they had a disability. Now, the employer did not know about the disability until he did what? In his letter, he says, by the way, I'm disabled. So now after he's not hired, he turns around and wants to say that was the reason why he wasn't hired. And he filed with the EEOC. Well, we were able to knock that one down and get rid of that one. But those are the things you have to be careful about these days. And with technology, the way that it's changing, let's look at a couple of things. Lawsuit-proof hiring process. 1. Accept applications almost exclusively online. Instruct applicants to remove birth dates and graduation dates from resumes and exclude personal information from cover letters. That's what you do. Now, 2. Have someone who won't be involved in the interview process review the applications and make initial availability calls. 3. Screen applications with computer software that looks for pertinent information, education, and training. Nothing is as blind to protect the characteristics as a computer code. So therefore, what you're doing is that you're taking this out of the situation where somebody is personally reviewing this, and now it's all based on, to make sure there's no dates there, there's no education requirements there, there's no way for them to put down about disabilities, etc. And then that makes the process a little bit better for you, and they can't come back and say, well, the reason why they let me go was because of these things. No, we had no knowledge of those things. So again, with technology now, apparently there's software that's coming out where you have the ability to be able to do that, especially online. Hey, you might want to consider it, take advantage of it. They got law firms out there sending people in now and applying for jobs, and if they don't get the job, now they're coming back and suing the employer based upon something that may have been said. So we got to start thinking with technology now to eliminate some of these lawsuits. All right, with that last comment, it's time to close out this segment. But let me remind you, you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday between 9:45 and 11 o'clock. Now, we don't get a lot of calls. We get the emails. I don't know if people are shy out there, whatever the case may be, but just let me give you a reminder. You don't have to give your real name. One person one time told us, yeah, but they might recognize my voice. Okay, fine, no problem. Send us an email. Now, you can reach us at 855-4J-POTS or 855-457-6887. Or you can email us at jameswilliampottsllc.com. Okay, I am Jim Potts. I will continue to fight the fight. Thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.